Okay, let's do it. It is Thursday, October 27th, 2022 at 9 o'clock. This is the Policy and Procedure Committee meeting. Call the roll, please, Amanda.
Aaron's,
Here.
Alt,
Here.
Barr,
Here.
Awful, here, sure.
Yep. Do we have a motion to approve the agenda?
So moved.
Is there a second?
Second.
Mr. Barr. All in favor, say aye.
Aye.
Opposed, same sign. The motion passes. Are there any public comments? There's no public here, so there must not be any comments. Mr. Walter talking. Committee chair reports, Mr. Behrens, management and judicial.
I think on management, the main thing is we're supposed to get our tile bids back. So we'll go through, open those. Judicial should just be regular reports.
You're gonna hear from me on the progress of the purchase of a building for a morgue.
Well, if you have progress, I haven't been informed that you needed to let us know.
Also give you a report on progress for waterproofing on the acquired building for animal control.
Okay.
Not a whole lot either way, but we're working.
Okay.
Okay. Mrs. Awful, Health Committee.
Yes, we will have our regular reports along with animal control and the new building coming up.
Mr. Bard, Tax.
The department heads will make their regular reports and the committee will be voting on a rezoning variance from RR1 to business.
RR1 to business, huh?
Yeah.
That sounds good.
Yeah,
Gonna make some money for the county.
well, one would hope so.
Mr. Alt, Highway.
We have the normal reports, with one exception. We're going to have to vote upon Mr. Moore's salary for the coming year. I suggested Moore could do a lot of things to help himself in our votes, but he hasn't volunteered them yet.
Oh. Okay. I will forego chairman comments. Mr. EMA is over on a problem over in Gilman, so we don't have that. So that brings us to talking about the county board meeting schedule for next year. I believe you have a copy of that in front of you.
All I got is that
It's a two-sided document, so you're gonna have holidays on one side.
On one side is the county board meeting, the other side is the calendar, so.
no committee meetings, that'll be fun.
I guess we can perhaps even talk about both of these at the same time if you want in some respects. We've got these put together, bringing us, put them together, I should say, not me, but this is something that we have to do every year. It's significant to note that this year, because there's a new board taking seat on December 5th. We actually don't need to approve these today. We can wait until we have them approved at the December meeting if we should so choose. I think the main issue has to do with the board meetings and so forth. In the past, there's been times when there's somebody promoting the idea of meeting at night or meeting at times other than 9 o'clock in the morning. That's really the only reason that I can see for either one of these two not being brought forth and approved at the next board meeting, which is the November meeting. But you'll notice that on both of these, it's in January when they take effect in December, so. So we don't have to approve them now, we could wait until the December meeting if we wanted to.
The only difference is that new members of the board, the new board itself could make this.
There'll be several new members of the board, I think four new people will be on the board that weren't there before. And there are 8 people on the board now that won't be there anymore. We're going from 20 down to 16 board members.
So have they always had the day after Thanksgiving off?
Yep. The only change in the calendar holidays is the adding of that Juneteenth holiday, which we actually did already this year, add that in. Otherwise, all those holidays have always been there.
They're also written in the union contracts, so you would have to renegotiate union contracts if you were taking anything away.
So I guess what I'm really saying is that it's up to us to decide today, do we wanna, we can table this until next month if we want. Or we can go ahead and approve it today and move forward.
May as well just approve it, and then if somebody has objections at the full board meeting, then they can state their objection, otherwise, you know, it'll be done.
That's fine, we can certainly do that. I don't say that there's any issue with it. In other years, I think from my recollection, we've usually approved this at the November meetings.
There's been some discussion held over though because of new
I
people.
mean, there's 2 ways of looking at it. If we do like Lyle is suggesting, it opens the door for discussion, and if there are changes to be made, they can be made between now and the December meeting. If we wait till the December meeting and there's changes, it can prolong the board meeting that day and maybe even not fully resolve everything to everyone's satisfaction, where if we do it now, the only real advantage that I can see in waiting for the final approval at the December meeting is that you have a new board seated, and it's that board then that's going to approve the
That's fairly
meetings
important.
for that month, for that year.
Because they're the ones
Now,
attending.
it's this board saying what the meetings are gonna be and for the coming year for the other board. But on the other hand, the majority of the new board is already in place, so.
I move that we approve the meeting calendar and the holiday calendar. Unless you think it should be 2 separate.
And I think one motion can handle both of them.
I'll second that motion.
Okay, would you call the roll, Amanda?
Aaron's,
Yes.
Alt,
Yes,
Barr,
Yes,
Awful. Yes. Sure.
Yes. Okay, that takes care of that. Sexual harassment training, 72%.
Yeah, I sent out the information yesterday, we're at 72%.
What miracle will happen next?
It seems like after we have these conversations and the email goes out, I tend to get a few more in, so we'll see where we're at by the end of next week, but 72% right now.
what about people who are leaving?
But since they've been employed in this year, even if they've left and they haven't completed it, it still counts against us. So for example, we got notified yesterday after I sent out the email that there's 4 employees that don't work for a specific department anymore that we were unaware of. However, they were on our payroll list, since the beginning of the year, so it still counts against us because it wasn't done.
Somebody like Joe Young that's been on, but if he just leaves now, why?
It still counts as he didn't have it done because he was still employed by us, so.
If you them making any comments lately about it since you sent out notices?
No, we just got informed, like I said, that we have 4 employees in one department that have been termed, but yet they haven't officially been termed because they haven't turned in the paperwork to Amanda, so. They're still listed as active employees. Goes back to what I said last month when, just need to get better at turning in the employee, list for hiring and termination, so.
Well, we're at 72%, we have 65 days left in this year until we start all over again.
You got it.
Seems kinda crazy. And we have to start taking it all over again, every year.
Yep.
Well, I don't know what our chances are of doing better than the 72% we're at now.
We'll see. My goal has always been above 80, so let's see what we can get done.
Okay. I guess we'll move on from that to our work on the personnel policy manual. This paperwork that we got here goes back to what we talked about at the last meeting, is that correct?
Yes, that's the whistleblower policy that the lawyer had provided as a sample. We left off on page 22 is where we'll start, but if you wanna go ahead and
Well, let's go back to
take a
this.
minute and read through the whistleblower policy. So it gives a summary of the law here, which the Public Officer Prohibited Activities Act prohibits a unit of local government, any agent or representative of a unit of local government or any other employee from retaliating against an employee or contractor who reports an improper governmental action, cooperates with an investigation by auditing official related to a report of improper governmental action, or testifies in a proceeding or prosecution arising out of a improper governmental action. And then it just goes on to verify those 3 statements there. I'll give you a few minutes to read through that since you have it in front of you.
Well, we're not gonna incorporate all this into our manual, are we?
No, I mean, you don't have to do that, no. But the one comment she did make on page 2 was that public bodies must distribute the law or a summary of it to its employees along with the public body's processes and procedures for reporting violations at the start of employment and at least once a year in accordance with the law. So basically what it's saying is we need to give all the employees once a year a copy of section 4.1 of the act.
We've never done that, have we?
Not to my knowledge, no.
I guess my question is, without having had the opportunity to look at this, what is it being suggested that we put into our book? All of this, every page here?
This is again the sample policy that she provided, so I'm assuming this is what she is suggesting we put in. She does make a comments on page 4. Prohibited activities act, reports can be made to state's attorney of the county in which the public body sits, okay? Those are just clarifying statements that she's commenting on. And then she did include the complaint of improper governmental action and or retaliation form that an employee can fill out.
This whole business about whistleblowers has always been rather frustrating for me because I think it contains so many loopholes or problems for the employer. If you don't, I mean, it almost renders the employer incapable of any kind of disciplinary action against the employee. If they've done it, if they've engaged in a whistleblowing act.
Well, it seems if that's just the norm these days, let it go into your schools and that starts right there. This is the same thing.
So it looks like the summary of the law, page 1 and 2, going into page 3. And this is just what I'm reading, is something that should be given to the employee upon hiring him once a year. And then it goes into the actual policy and procedure on page 3. I could be reading that wrong, but that's just the way I perceive it. I don't know if this is something you want to run by our state's attorney, because it does involve him as far as.
I think maybe we should table this part of it, at least give us a chance to read through it, digest it a little bit, and maybe see what our state's attorney thoughts are on the matter.
Sure. Alright, so.
I guess like I was gonna say, you know, to me, I understand the Whistleblowers Act, and I think the intent of it is probably a good one, that if somebody observes something improper being done, they should have some protection, but by the same token, I think it opens the door for abuse on the part of the employee. If they engage in a Whistleblower Act and then it takes away your employer's right to terminate them for what might be legitimate reasons, such as if they're an at-will employee and you're gonna have to reduce your force or something, like, you know, you say, okay, you're the one. Decisions that are made to terminate employees are often made for different reasons. Those reasons may or may not be subject to discussion amongst various individuals. They may not always be the best reasons in the world either, but the employer retains certain rights insofar as deciding who they want to have working for them. And so some of it, I can see where there's some conflicts or head knocking that can occur or something like this, but nevertheless, we have to deal with it and we have to have it, so I don't know that there's a whole lot else we can do. But I guess the best thing is we can table this, study it over at our next meeting, which if you noticed on the agenda, we'll be discussing a little bit when we're gonna hold the next meetings. So let's pick up where we left off with, okay, Joe?
Yep, again, we're on page 22, this is the policy of conflict of interest. One of the things that is commented here says the attached whistleblower policy, she would recommend that the county incorporate this sample policy into the handbook. So the purpose of this is to set guidelines to provide general directions so that employees can seek further clarification on issues related to the subject of acceptable standards of operation. So one of the things that she has underlined is in paragraph 2 under policy, an actual or potential conflict of interest occurs when an employee is in position to influence a decision that may result in a personal gain for that employee or for a family member or third party with whom the employee has a close relationship as a result of Iroquois County's dealings. The next paragraph, personal gain may result not only in cases where an employee, family member, or third party with whom the employee has a close relationship has a significant ownership in a firm from which Iroquois County does business, but also when the employee, family member, or a third party with whom the employee has a close relationship receives any kickback, bribe, substantial gift, or special consideration as a result of any transaction or business dealing involving Iroquois County. So she's adding in with whom the employee has a close relationship with. Is that okay to add?
How close does that have to be?
I don't know. I mean, I would assume that you don't wanna set any sort of detailed standards, cause it could catch you either way.
I mean, that's not just being related to somebody, it's being close friends with them or whatever.
Right. Is something you wanna keep added in, or?
Right now, it's not limited to having a close relationship, it's anybody. Why shouldn't we leave it that way?
Well, it's up to you, this is just a suggestion.
Do we, I mean, I guess it depends on what we want to allow. When you say you're limited to a close relationship, aren't you opening the door to somebody saying, well, it wasn't a close relationship, so I go ahead and do it?
So somebody could actually get something done to benefit a business or person in their area that they aren't involved with in any way, but that they see as a political benefit for them or whatever, or benefit for their job.
I think in general, without ever getting into any real discussions about it, I think at least amongst the board members, we've had people excuse themselves or abstain from voting in situations where they thought there might be a perceived conflict.
It's a perfectly logical way to handle it. Abstain from voting, you're no longer acting on this particular matter within your position as a county board member.
This isn't just for board members, it could be a building inspector that goes out.
Sure. Has a different relationship besides what is going on in this.
But I guess the.
He's got a right,
question is-
he's got an obligation to report what he has seen. And if it puts him in a vulnerable position from either side, he should just abstain. Required to abstain, I guess you'd say.
I guess the thing that bothers me is putting a close relationship in there, because that's a term. It's hard to define exactly what it is, but also, why do you wanna say if it's not a close relationship, you can do these things?
Yeah, I don't have a close relationship with that person, so go ahead and give them a bribe or a kickback.
Yeah, I just don't think we want any of that going on.
Yeah.
Are we making sense, Joe?
Yeah, do you wanna leave it out?
I think so.
I don't like Jill, go ahead and bribe her, it makes it easier for me to work with her, you know?
I'm okay with that, I don't care if you like it. Alright, under 3, responsibility, it is the responsibility of employees to notify the Iroquois County Board Chairman or State's Attorney's Office and or Department Head Supervisor of any potential conflict of interest and to avoid actual or potential conflicts of interest. Do you wanna keep that in or leave it out?
Who we're notifying now, the state's attorney and who else?
Notify the Iroquois County Board Chairman and/or the state's attorney's office and/or department head supervisor of any potential conflict of interest. And then added in here is and to avoid actual or potential conflicts of interest. I think that's okay to keep in, it's basically saying that it's the responsibility of the employee to report to one of these three persons. And they added in also, you know, make sure that they're avoiding actual or potential any conflicts of interest, so.
I guess the only question that I would have in something like that, I think that having to be notified is good. Do you wanna have just one person of those three notified, or do you wanna have two of those three?
I think that we had talked about this and we gave them options because if it is somebody not involving the department head, then they can go to them first, which is the order that we would prefer them to go to. However, if it is a department head or supervisor, then there's two other options there with the state's attorney or the county board chairman. I think you should leave the department head and supervisor in there, cause if it's with another employee, you know, obviously going to the supervisor is fine, but.
I'm not suggesting that we take any of those three out, what I'm suggesting is that if you have just one, let's just say either the department head or the county board chairman, if they decide to just put it on the back burner and not do anything about it.
Then they have they have the option to approach somebody else then.
Right.
No, but that's not,
I know what you're saying is they've approached the one person and they don't do anything, well, if in a reasonable amount of time, somebody doesn't do something, then I would go to the next person and, you know,
What can they do other than agree with you? You got a conflict of interest.
well, and if you go to all three of them, eventually, and nobody does anything, well, maybe there isn't a conflict. But I think in the law, it also states that you can go to any state's attorney, so they could actually go to Kankakee County State's Attorney if nothing's done here.
Well,
what I'm saying is that if two of the three are notified, there's more likely to be something done than if just one is notified. But it's not, I'm not saying that it should be the person. Let's say that it's somebody's whomever, down low on the totem pole, let's say, just as an example. I'm not saying that they have the responsibility to notify to them. If they go to their department head, then the department head should notify either the state's attorney or the county board chairman. Or if they go to the county board chairman, then he should notify the department head or the state's attorney, whatever.
if he goes to one, he's done his job. Especially if he goes to his
He's done his
department
job,
head.
but I'm saying that then,
Department head now is responsible for what he does.
right, that they should notify.
That should be put, the department head's responsibility to take it.
I don't know if there's a way how we can word that, but I think that,
Yeah, I see your point.
I think that ensures that if there's a potential conflict there, that it's gonna be something that's gonna be stopped.
It's gotta be it can't be the state's attorney of Cook County that you got to, because he's gonna laugh at you and send you home.
If there's a conflict or a potential conflict, it should be resolved.
Within the structure of this organization.
Right. But unless you,
I guess that's going to come down to, they fill out this form. Who does that form get distributed to then? So they come to you with this form. Are you saying it should automatically then, a copy of it go to the department head and the state's attorney, or one or the other, or?
however we would wanna put it, but I'm saying you have three people involved, at least two of them should know about the problem. Once the problem is identified. Because that ensures something's gonna get done. And obviously, if there's a conflict, I think we want something to be done. I think we want it to be resolved. Either there is no conflict or there is, and we have to handle it and deal with it. So I'm just saying that if more likely something's gonna get done if you know that the two.
I guess the easiest way to do it is to just say that the complaint should be forwarded to, once the complaint is received, it should be forwarded to all three of those. That way it's done.
Well, what if the complaint's against the department head or supervisor, they don't wanna give it to them?
Right.
Right.
I think you're
But
better off leaving it as we already had it written, saying and or, cause that gives them options depending on the situation that they're in.
He's,
Say if I had a problem with John, I'm not gonna report it to John, I'm gonna
Right.
report it to the state's attorney. It is then the state's attorney's responsibility to take it to the next level, is what I'm reading it as. Or if
Right.
Amanda has a problem with me,
About that too.
she's not gonna tell me, she's gonna go directly to John and say,
Right.
John, this is my issue, and then John, it's his responsibility to either inform the state's attorney, which I believe he would, and then
Okay.
involve me
But-
eventually, but
but what we're looking at here is, okay, yes, you are confident John would inform the state's attorney, but down the road with a different,
and if he
person in
doesn't, I'll
charge.
give him some time, but if he doesn't, then I'm gonna go
then
to the
you
state's
will,
attorney.
okay,
And I think that's
Which is
why we
what I would
left
do
in,
too.
and or, it gives them options.
right.
Well,
And then, once all those options have been exhausted, if nothing is still done, then that's on us, that's not on that employee putting in the complaint. So, I think you need to leave it and or, and so does the attorney, she didn't say anything about that, she's just adding in to avoid actual or potential conflicts of interest, so she's just saying, not only is it the responsibility of them to notify, but to also avoid, any particular conflicts of interest. I'm not gonna go to say, can't Sue, who is the department head of the clerk's office, and complain to them about something in my office, which is in the treasurer's office, you know what I'm saying? That's the way I read it, so I think it's fine to keep in, that's my opinion.
if you took the word or out,
Nobody usually does, I just give it, and if y'all want it, roll with it, if not, it's okay.
I understand what you're saying, Joe, but it doesn't, I'm not sure that it resolves the concern that I have. I'm trying to ensure that, because,
So do you wanna table this so you can think about it,
well.
on how to reword it, or?
I think we ought to be able to figure something out now. I mean, it's just to me,
Because she's not questioning what is actually stated in the responsibility, she's just adding in that end of the sentence.
right, I understand that, but I'm questioning what the paragraph is saying and what we're trying to accomplish with it.
Okay.
If you took the word or out,
But I still think that you need to leave it in, because if I have a problem with the department head, I'm not gonna turn in a report to the chairman and the state's attorney and the department head, because I have a problem with that department head.
no, but you're not, but somebody that's way down in the bottom of the.
But this is saying it is the responsibility of the
This is the
employee,
employee's responsibility.
not the employer.
Right, I understand.
So is there another section that has what the employer has to do or not?
Well, this is an employee handbook, so.
Okay.
I guess
Yeah.
we can leave it the way it is and see what happens. It just.
I mean, I'm just giving my opinion, this is, it's up to you, I don't have a vote.
Well, what I'm talking about is a situation where it could be an inadvertent mistake. It's, let's say something is turned into the department head and they got a piece of paper and it gets put in a pile. Maybe it somehow, because of whatever it is, it gets forgotten about.
Right, and then me as the employee, knowing it's my responsibility, if my department head didn't do anything, I'm gonna give them a week. If they didn't do anything or say something that they are working on it, then I'm gonna notify the next person on the list, either the county board chairman or the state's attorney's
Okay,
office,
but that's you.
right? But that's my responsibility as the employee. So let's say Fred has an issue with its department head, he puts in a complaint, the department head does nothing about it. Fred's either gonna go, whatever, it's not that important, or they're gonna go, hey, that is important, I can go to one of these other two people now. It's up to the employee, that's what this is saying, it's their responsibility.
And it is an employee, as she said, it's the employee handbook, not the
Yeah, I
management
understand.
handbook.
And the procedure on that next page states, if there is a potential for conflict of interest to exist, the elected official or department chairperson will notify the Iroquois County Board and the state's attorney. So then that states what the procedure is if the conflict does arise.
But that gets back to what I'm saying, is that if the department head somehow gets lost in the shuffle. I don't know, maybe we cannot cover that issue.
Well, I don't think it can be as black and white as what you want it to read, because there's so many different scenarios.
Um,
I mean, that's kind of what I'm getting.
It's just
It's
that
the issue.
some of the issues that have arisen over the years, it just seems like, well, it isn't quite covered exactly that same way in our manual, and so now we're stuck. We've had some issues like that, and that's, I think, part of what we're trying to prevent by having the book, and also by trying to have the book cover as many things as possible, so.
So how would you want it to be read?
I don't know,
I mean,
I would just,
it's never gonna cover everything. You're gonna have to just use it as a guideline, and if there's something that doesn't exactly fit, then you just have to deal with it, with the advice of the state's attorney.
well, I suppose, like what Amanda's saying, that, you know, it's the responsibility of the department head to notify the others. Maybe that's the out. If they don't do their job, then, you know, in any situation, if a weak link in the chain breaks down, the whole chain breaks down. So if somebody doesn't do their job,
Which should be part of the department heads, county board chairman, state's attorney, is take immediate action, notify other people of the potential of a problem here.
that's,
I mean, that's gotta be in their description, not in this one. I mean, maybe you can put it in okay, but it doesn't have to be in this one.
well, it's.
In order to be in theirs, it's gotta be
Isn't
important.
that kind of what Amanda's saying, and that,
Yeah, I mean, we can read on before you agree to keep this or leave out, if that'll help with your decision.
Yeah.
Okay, then
It's
we'll
their
read on.
responsibility at that point. You got them on the hook after.
So then the next statement is the procedure. So during the recruiting of employees, interviewing of potential vendors, and searching for subcontractors for Iroquois County, the elected official or department division chairperson will review the individuals, groups, or companies for potential conflicts of interest within their area of influence. If there is a potential for conflict of interest to exist, the elected official or department division chairperson will notify the Iroquois County Board and state's attorney. The elected official or department division chairperson will obtain approval from the Iroquois County Board prior to contracting with family members of employees of Iroquois County. She doesn't have any recommendations here. Does that help at all with this responsibility? Because we're talking about conflict of interest in choosing vendors and what sorts. And I think that, you know, we're talking about before, what John was saying is more the conflict resolution, not the conflict of interest. So, in my opinion, again, I think what is stated under responsibility is fine. She has no suggestions for procedure. And just need to know to keep it or leave it.
okay, let's leave it. I think maybe that'll work. We'll have to make it work.
Well, it boils down to that anyway.
Okay, so,
And we weren't going with their changes to the second section, correct?
no, we were not, that one was, we were leaving it the same.
We're just leaving it as kind of, okay.
Alright, so page 24 is the continuation of benefits, the COBRA. If you go down to responsibility, it states currently, it is the responsibility of the employee to notify county board executive assistant when a qualifying event would cause his or her insurance coverage to cease. The comment is, the county has an obligation to notify the health plan of a triggering event so that appropriate COBRA benefit notice is provided. I think that's basically saying the same thing. So maybe she's good with that?
And we're leaving that the way it is.
Yeah.
Yeah, I agree with that.
So going down to emergency preparedness, inclement weather, power failure. She recommends revising this policy so that it is more consistent. See comments below regarding contradicting provisions. So under section 2 policy, she kind of changed this whole thing up, so I will read it as she changed it. Adverse weather conditions, power failure, equipment failure, or other conditions may necessitate that Iroquois County close county offices during all or a portion of normal business hours. When questions arise due to such circumstances, the county board chairman shall be contacted and shall determine whether offices shall be closed or whether employees, if they are at work, are permitted to leave work prior to the end of their normal shift. If the chairman is unavailable, the vice chairman shall be contacted and decide the matter. If both the chairman and vice chairman are unavailable, then a committee consisting of the resident circuit judge, or in his absence, the associate circuit judge, the sheriff, and the county clerk shall decide the matter. Going home early due to weather conditions does not apply to the county highway department.
Just follow your way home.
She basically reworded that paragraph to say the same
That one
thing,
duty.
so I'm okay with leaving
But why
her
house,
changes
right?
in.
I think what she's got in there is what we're doing.
Yeah, she just reworded it a little bit, so. Alright, so employees are expected to show up for work regularly and on time. Occasionally, however, weather may become a factor and employees should not attempt to come to work in dangerous weather conditions. The comment says that this contradicts the paragraph below, which states, in case of severe weather, employees must look out for their own safety. However, okay, so she wants to take out the sentence, in case of severe weather, employees must look out for their own safety. However, this doesn't mean a free day off. She just wants you to leave in unless the Iroquois County Board Chairman or Vice Chairman has closed the county facilities. Employees are expected to come to work, otherwise the employee will be charged one vacation day. So what she's saying is that those paragraphs contradict each other. So she's suggesting that you take out the sentence, in case of severe weather, employees must look out for their own safety. However, this doesn't mean a free day off. Which I agree, I think you need to take that out.
How do we cover the cases of an employee that is prevented from getting to work for whatever the reason might be, weather related? They have to then take a vacation day?
On case by
If
case.
the highway department didn't plow the snow in front of their
That'd be a
house,
good reason,
they can't get to work.
that's right.
If it's that bad, in most cases, you will close the facility.
Sure.
Okay, again, I'm okay with taking that out. You guys wanna take it out or leave it in? I think it just reads. I'm okay with taking it
Well,
out
I
because
mean-
I think it reads
Yeah, I mean,
very strange.
the way it was, they were still gonna be charged for vacation day.
If we're open, you're expected to be here. If you cannot be here, basically you're using a vacation day. Again, I think that's gonna be dependent on each department head's decision.
Does a department head have the ability to close their department for a day?
Elected officials do, from what I understand.
So if John or I don't close it and the treasurer, the clerk both close their office, you'd still be.
I could be
charged.
wrong, I'm just.
I don't
that's how
believe that that's true, Jill. I think
Okay.
that the county board sets the hours for the building, so
Okay.
they're in charge of the building.
When the building is open, where all county offices are expected to be open.
Right.
Okay, yeah, see, that's what I said, I don't necessarily know.
But I could believe something different than someone else. I can read that statute wrong,
Right,
but the county board is who sets the hours for the elected officials.
gotcha.
Now, that's what it says.
Yeah.
And I think that's pretty pretty clear in that regard. It's just a case of an employee makes a legitimate attempt to get to work and prevented from doing so. It could be an automobile accident or something else, you know,
Get stuck in the big snowbank,
whatever.
anything like that.
Life happens.
Then you tell them you made too big an effort.
Yeah.
I guess the comment that Jill made about being up to the department head, does that mean if they don't take a vacation day, they just lose a day's pay? What is the penalty if they don't show up for work?
Well, this is saying if they don't show up to work, they'll be charged a vacation day. But I think for the most part, the department heads usually,
What if
and again, I could be wrong, I don't know, but I think what is being done now is if they use their best judgment on whether this person truly cannot come in or not. I don't know, I could be wrong on that one too, I don't know, but per this handbook, it's saying that they should be charged a vacation day,
But if they don't have any vacation time remaining.
then they don't get paid.
I think it's their choice. If they choose not to come in because the weather is bad, even though the building is open, then that employee is going to use a vacation day or not get paid or use comp time or whatever. But again, I could,
That last paragraph is the one that's difficult. Because,
And that's what she's saying it contradicts
yeah,
everything.
I mean, how do you know if they made an effort to make it in, you know?
And it could be something in where the person lives, between there and the county office that prevented it from getting there, but everybody else got it there.
Well, they could be at the corner here and get a call, we're closing the building. Well, they made an effort to come, but they never actually made it here. So how do you prove that they did or didn't make an effort?
That's true. Can't really
I would
prove-
simply put it as, I would take this out and simply put it as, if the building is decided, or the facilities are decided to be closed, that the employee is gonna get paid. Because again, I agree with you, you could argue that till the cows come home, how are you gonna decide if they made an effort or not? I mean, I could be sitting on my couch and saying, man, I tried to get all the way there, I'm at the corner,
You put on,
I'll turn around and go home, and I'm like,
you put on
like-
your jacket and took it off.
right, so.
I think in actual practice, I know that Brian and I have had conversations around 5 o'clock in the morning on some days when weather was questionable.
Gee,
And I think there's a network whereby she's able to contact other department heads and then they in turn contact their employees to notify them in person of what's going on. Obviously, there could be a situation developed if a storm struck here at 8 o'clock in the morning where we had to close the building, where what you're talking about could occur, but I think that's an incident that would speak for itself. Probably isn't any way that we can ever cover that, so far as our policy manual.
I think you would be best to take out the 3 bottom paragraphs and adding in if the county facilities are closed due to inclement weather, an employee will still be paid, and not add in all that other conjecture about if they try to come in, if they feel it's unsafe, because basically they're getting paid if the facilities are closed. If they're not, it's up to them to decide what time to use.
The way it is now, that's what happens, right?
Yeah, for the most part, I believe, with most of the departments.
Those events are primarily snow events. We've had one event that I've been associated with where there was a storm in the summertime when we closed the building down and then, because there was no power. And about 9:15, the power came on. We could have been open, but it was too late.
But that's a rare event.
Right, exactly. And that's why I said one
Yeah.
time.
I mean, this is gonna be very hard to cover every kind of
Right.
event that exists.
Right, exactly.
So, did the generators not work?
Generators don't cover everything.
Somebody broke into my house and held me hostage, I can't get there today. Nobody else is affected, the county is running,
Why would they break into your house? You don't have any money there.
that's right.
Right.
Don't have
So-
a dime,
It's all across the street.
yeah, go over there,
So basically you're saying
don't force me
the
to.
point where she's got it marked, if the county offices are closed from there down, to eliminate that, correct?
Notice they use in case of weather.
I'm saying those 3 paragraphs there from employees are expected to show up to the end. Take those out and simply add in the paragraph that if the county facilities are closed or closed early, all scheduled employees will be paid. If it is the employee's decision to not come into work, they must use their earned time. Basically, you're saying if we're open, come to work. If you're not coming to work, that's your decision, you can use your time.
Why do you wanna take out the phrase about employees are expected to show up for work then?
Well, I mean, you can leave that in, that's fine.
I think the rest of what you said makes sense, but I think having a statement of that nature emphasizes in the mind of the employee that they have an obligation or expectation to show up for work.
So you would
So
just
you
leave it,
want, you want to say employees are expected to come to work. If the county facilities are closed or closed early, all scheduled employees will be paid. If it is the employee's decision to not come into work, they must use their earned time. Is that okay to replace those with?
That sounds, I like that, but I don't, with the rest of the guys.
read it again.
So I would put in there, employees are expected to come to work. If the county facilities are closed or closed early, all scheduled employees will be paid. If it is the employee's decision to not come into work, they must use their earned time.
I mean, I do like that first sentence, show up to work regularly and on time. You just have
I think
to
that,
come to work,
okay, so
because,
guys are getting technical.
yes, because there are people that, well, I came to work, well, yeah, but you weren't on time,
Expected to
you know.
show up for work regularly and on time. Okay, so employees are expected to show up for work regularly and on time. If the county facilities are closed or closed early, all scheduled employees will be paid. If it is the employee's decision to not come into work, they must use their earned time.
Not come into work when the facilities are open. Cause she has, right before that, the facilities are closed, well,
There's a difference between closing and unclosed time.
right,
Into work when facilities are open. Okay, employees are expected to show up for work regularly and on time. If the county facilities are closed or closed early, all scheduled employees will be paid. If it is the employee's decision to not come into work when facilities are open, they must use their earned time.
that sounds good.
I like it. Alright, so page 26. If the county facility remains open and employees do not come to work, they may use a personal or vacation day instead of losing pay with their supervisor's approval. So earlier in the policy, it states employees must use a vacation day. Are they allowed to choose between a vacation, which we deleted that. So on this sentence, I think you need to, they must use, we can just take out that and put in they may use earned time? Or do you wanna use it, okay, let me go back. So they don't get to use sick time, so it would be personal time or vacation time.
You have earned time, so will that just cover,
I would think earned time would cover everything.
unless you wanna spell out
Well, unless you
vacation time,
don't,
personal time, comp time, or you could just leave it as earned time.
cause you said you don't want to use sick time, so earned time, sick time is earned time, isn't it?
Yeah, I mean, I don't know.
It is, but it's in our policy in here for sick, I think it specifically states that it is for illness, doctor's appointments. I think it states what sick time is to be used for, and it's not to take off for weather related purposes.
Does sick time require a no from the physician?
No.
So if somebody says I'm sick,
You can't prove it. So I think you're alright with earned time, and I would adjust that to that paragraph as well. They must use earned time, because certain departments have comp time too. What it says in our sick policy is if it becomes a perpetual occurrence in the it is up to department head to request that documentation. And really, after 3 days of being sick or not at work, they should be
They should provide you with a note.
providing with a note and also looking into FMLA. We learned that at our employees' best practices.
Doesn't that
Yes,
sentence
we did.
reiterate what you've just said though?
If the county facilities remain open, employees do not come to work, yeah, it does, so I mean, you could just, you could lose that whole thing. Yeah,
Cause you
I would
basically
agree with
said
that, you're just saying the same thing over and over again. Okay, so the next part is page 27 under procedure. So what it currently says is each department head supervisor will perform at least annually emergency preparedness activities to prepare employees for safe and effective responses at each worksite. She doesn't recommend making statements like this as it could be used against the county. Instead, you could state that such training will be performed periodically in the discretion of the department head or supervisor. Okay, I understand that, so instead of, we can either get rid of that altogether, or we can state it as each department head or supervisor will perform emergency preparedness activities to prepare employees for safe and effective responses at each work site. In due to their discretion.
Periodically at the discretion of the department head.
Yeah, so do you wanna add that sentence in? Take out will perform and add that, periodically
Basically the last
Yeah.
lines of the,
in the discretion. In their discretion. Okay, so each department head or supervisor periodically in their discretion will perform emergency preparedness activities to prepare employees for safe and effective responses at each work site. Is that okay to keep in? Alright, so page 28, do you wanna keep going, it's 10 o'clock, or do you wanna stop here? Keep going? Okay. Let's see here, so she didn't have any changes on page 28, but on 29. Okay, so under suspension, in case of a need to allow for fact-finding investigation, the supervisor may place the employee on an unpaid suspension. If the investigation results in the allegation being unfounded, the scheduled work days work of the suspension will be paid. The comment is, if the issue needs to be investigated to determine whether misconduct occurred, I recommend a paid administrative leave pending the result of investigation. Also, employees who have due process rights like union employees or employees with statutory job protections should not be placed on unpaid suspension unless they have first been provided with written notice of charges against them and an explanation of the employer's evidence and the opportunity to contest the charges at a hearing. So she's suggesting that they be placed on a paid suspension.
what exactly are the kinds of charges that we'd be talking about?
Doesn't matter.
Any of these down here.
I mean, if it's something that's bad enough to be criminal, they'll be arrested and removed.
So are we gonna have paid leave while they're being arrested?
Well,
It's not right.
unless they're convicted, they're presumed innocent.
So you could state
It might take a couple of years to.
and place the employee on, you could leave this the same and just add in unless they are under, what was I gonna say? I lost my train of thought, sorry. Unless they're, under statutory job protection.
What do the union contracts say? Anything?
Before termination, they should be before any sort of suspension or termination, they should be notified in writing of such allegations. I don't know without looking at it directly, because I don't have it in front of me, but.
Because we don't have anything in there that contradicts it.
Maybe we should
I don't
look at that
know,
before we decide on this.
This list of things here seems.
I think we need to look at the union. Policy.
What does our union agreements right now cover on this subject, Jill, do you know?
I don't know off the top of my head without looking at it.
I just, some of the things that are listed there are criminal things that could take a long time to be resolved if you have to pay somebody during that period of time. I think that's,
But then to not pay somebody who ends up being innocent, you just,
Well, if they end up being innocent, then you pay them.
okay, but in the meantime, they've lost their house and everything else because they didn't get an income.
Which then they can counter sue you for loss of income.
but if they're guilty, then can you recover
Somebody
the
should have
money?
paid for their house if they weren't guilty.
You won't be able to recover the money.
If it was
But-
something that could be resolved in a matter of a day or two, I wouldn't have an issue with it, but if we're talking months or
Thousands of
longer,
dollars.
that's my concern as far as any paying to somebody.
Yes. But you have to go with the presumed innocence of anybody.
Mhm.
Until proven guilty.
In most of these cases, when somebody would, it would be pretty clear that they're doing something wrong. If you choose to follow into that, but it's the criminal part of it that concerns me.
Well, and the criminal part is where they're presumed innocent.
Well, that's true, but let's say just as an example, an employee in the treasurer's office is accused of embezzling money. You must have some pretty strong evidence to accuse them of that. Are you gonna tell them you don't want them to come to work and keep embezzling money? You're gonna pay them while they have a trial? That trial might take 2 years before they're found innocent or guilty. In the meantime, you paid them $60,000 or more? Is that what you want us to be obligated to do?
I guess at this point, we need to ask the state's attorney what he thinks. Okay.
To me, that's not reasonable that we should have that kind of an obligation.
They found the money in the back corner of the closet, nobody did take it.
Well, and that's why you suspend somebody so that they can't bring the money back or redo the books to cover their tracks.
It's
It's
just.
a sticky
it's just-
situation.
In the meantime, you had all this time off.
And fishing. Fishing for more money. Well,
And they can't
I
pay
think,
about it.
I think the things that are covered in this section, like I said, outside of
That's
the
out of our
ones probably make
jurisdiction.
sense. Because they're things that we would probably resolve in a matter of a day or two. If somebody got in a fight with somebody, we said, well, you go home today, we're not, and don't come back tomorrow and we'll,
Take your boxing gloves with you.
I mean, or something of that sort. That's
Depends
one
on who
thing.
they were boxing.
Yeah,
But if somebody's stealing money or done some other act of a criminal nature,
If someone is suspected of stealing money.
okay,
Money is missing.
now, if money is missing, usually you're gonna conduct an investigation and try and determine where,
I think
where
normally-
it's missing.
Normally, you're always innocent until proven guilty, and then when they are proved guilty, part of the restitution would be paying back their wages.
Could be.
yeah, but he's gonna get them back.
If you can get it back.
Right. I think
Not
that's
working, how they gonna pay
But-
it back?
Yeah.
the chance you take, but then it comes back twofold, if they are innocent, you haven't paid them for, like you said.
We
So,
have,
I think it's one of those, you got one
similar
of the
problem,
questions.
but not exactly the same right now with the prisoners in the jail. Where if they go to the hospital, we have to pay their medical costs.
Mhm.
And we're entitled to try and recover that. Sometimes we do get some money back according to what we've been told. Most of the time, we don't. We're out that money.
They got insurance.
I think it's a technical enough thing that we probably need a technical answer from the
Yeah.
state's attorney on how to word it.
Exactly
I
right.
agree.
We can't word
I'm
this.
fine with that,
Okay.
but I think we need to get some clarification on that part of it.
Alright, so then we'll move on to page 30. Which, okay, she has a formatted error here, then on 25, unauthorized distribution of literature or solicitation during working time, so she just reworded that, I'm okay with that. Any other act, again, jeopardizes health, safety, I'm okay with those changes, that's just wording. Interviews, okay. Alright, so interviews or conversations that may result in discipline will be conducted between the supervisor and the employee. The employee may choose to have a coworker or representative present during the meeting. The supervisor may also choose to have a witness present. The comment here is, I only recommend this to the extent required by union contracts.
What does that mean? I think if the department head wants to have a witness present, that makes sense, and I think the employee should have that right also.
Right,
Right.
I don't-
so we can leave that if you'd like.
What was that?
Is that something you wanna leave in then?
Only what, recommend this to the.
She only recommend this to the extent required by union contracts, so she's saying that she wouldn't put that in there, she would just basically say that the interviews or conversations that may result in discipline will be conducted between the supervisor and employee.
I don't know why the union contract would have anything
Otherwise-
to do with it.
Otherwise stated differently per union contracts or something like that.
Well, the union contract some of them may state that they have the right to have their union rep with them.
Mm-hmm.
Yeah, then we have a right
Which
to
I think
have
is saying the
ours.
same
It's the
thing,
same
I'm
thing.
okay with leaving
Union representative is the same thing.
Sure.
They can have their lawyer, they can have a union rep, they can have their mother, or
They're gonna be there.
whatever, they can have one person.
Okay, so then moving
There were
down,
4 people in the interview, 2 on each side, that's
Yeah.
basically what
We'll
we're
have to
saying.
ask for mommy to come in. That'd be
so
fine.
then moving down to some situations may warrant skipping one or more of the steps in the taking out warning system corrective action process, or taking out warning system and putting in corrective action process, I'm okay with that. Sounds better.
Okay.
Alright, so corrective action may have an effect on annual evaluations, transfers, promotions, and instead of saying pay increases, compensation, which I'm okay. Changes. Each employee has the right to express his or her views concerning Iroquois County policies and practices to their supervisor. Each employee is responsible, however, for expressing these views in a fair, honest, and professional manner. She wants to take out every employee should be committed to making positive and constructive criticism of disciplinary rules and regulations.
Yeah, they don't have to criticize or.
So,
Why does she wanna take it out? Did she say?
she doesn't have a comment there, no, but it's basically saying that they should be committed to making any sort of criticism
Yeah.
on
Yeah,
the
that's
rules
fine.
and regulations,
Well,
but
If they want to, they can, but they don't have to, that's saying they
They
have to.
Okay, yeah.
so we'll take that out.
They don't have to say a word if they don't want to.
Alright, so we are on page 32.
Every time somebody complains to me, I always say that, are you doing this because you want to or because you have to?
The only comment on this
You do?
page is
That usually throws them off.
keeping more space available for descriptions, which I'm fine with that, we can do that. So then moving on to page 33, employment classification, she has here under policy, part A, exempt full-time, benefit eligible, a salaried employee who is regularly scheduled to work a minimum of 35 hours per week and who meets the minimum salary requirements and job duty criteria set forth in the Fair Labor Standards Act for exempt employees is what she suggests putting in, and taking out is designated as full-time employee. I'm okay with that. Everybody else okay with that?
Yep.
Alright, so under responsibility, she says the meaning is unclear, so part A, it is the responsibility of the department head or supervisor to provide a consistent scheduling pattern and to provide employees continuity in types of employment.
I know what that's addressing, but I'm not sure how to clarify it. In the past, apparently, this is years and years ago, there was a department head who would lay off an employee that wanted to work. They would find another job and they would call him back to work and then lay him off again. And they were just messing with him like that.
Oh, okay.
So did the employee file a complaint?
I don't know, that was before my time, I just was informed of it.
So how can this be written to where it's more clear?
Why did he come back?
Because he wanted his job with the county, because the county jobs have benefits that other jobs don't necessarily have.
If you get laid off and then the employer calls you back, you don't have to come back.
No, but he wanted the job because of the benefits that the job offered versus the job that he had
How
taken.
are you ever gonna?
I think that sentence needs to come out.
If you get laid off and then you get called back and your work habits aren't satisfactory or some other reason comes about where you have to get laid off again.
No, this was a case
I know the case you're
specifically.
talking about and I understand that, but I'm saying, On the other hand, you could have a situation arise where it's entirely legitimate
Which
as
is
well.
why I said I don't know how to put it in there.
You know, I don't
Well,
know.
I agree with, Jill that we should just take it out of
I
there.
think you just need to take it out, cause it doesn't make any sense. And for each department, it's gonna be different
If you're laid off,
Different scheduling.
scheduling and patterns and things as such anyways.
if you're fired or laid off, well, firing is different than laying off. If you're fired, your benefits stop.
Right.
I mean, you're done.
I mean,
You
if
have to
you're
start
laid
all
off,
over if
normally
you
they
come
would
back
go
to
on
the-
unemployment until they're
They're just
called
different
back.
ways
They
of
want to keep
saying,
the
you can
job.
say we're gonna
I
furlough.
mean, I don't know the
you.
circumstances, I don't know the circumstances, so.
You're on a furlough.
But I agree with you, I don't know how you would say that, and I
I'd
think
rather
it's
go
better
on
off
that in
just
case you
taking
do
it out.
wanna come back.
Well, I mean,
Everyone
they said
has
it's
to come back.
unclear.
If you're never had,
If the
And it
employer
is,
wants
it's
to
very
lay you off,
confusing.
99.9% of the time, you're not gonna have
if
a
you're on
department
furlough,
head
you
that's
still
gonna
get
do that.
benefits.
But
Schedules aren't always consistent either,
I did fire
depending
Kirby
on
and
things.
And then why they're not.
Oh.
Most of the offices are 8:30 to 4:30, but some,
so now who's gonna bring in the donuts?
He was being ornery. Anyways, so
I say take it out.
take it out.
what do you guys think?
That's fine.
I'm going more furlough.
Okay,
Take out. Okay, so
we'll go about another 5 minutes with this.
okey dokey, you tell me, boss. Alright, page 34, C, it is the responsibility of the finance department to maintain proper records of status changes and to keep an accurate record, I like that, vacation, sick, and holiday benefits. I'm okay with that.
Why is the
She-
finance department supposed to do that? I thought the executive assistant is.
Well, she's in the finance department, and when she's not here, I take over.
I know the way we work it, but the way we have it written is that. But I'm questioning.
Well,
Because
I mean, if
payroll
that-
has to do with finance, and it's in the finance office, and so is the executive or assistant.
well, it is vacation, sick, and holiday benefits, which is all part of payroll, right?
Because I think we went through and changed everything to say finance department, because it all comes through the finance department,
Okay.
rather
And
than
like in this
reading.
situation, if something were to happen to Amanda, you know,
Right, then you'd have to go
God
through.
forbid.
I went
You'd
ahead
have to go
and,
through and change everything to be, instead of executive assistant, you'd have to go through and change it to
yeah,
something else.
some things we specifically say executive assistant, but in this case,
I think we just changed it to finance department.
Okay, well,
because
I.
technically the records are all kept in my office, so anyways,
And that's, you're right, and that's, well, it's just a matter of distinguishing. I realize that there's an interchange of responsibilities that you and Jill have, yes, just from.
It's still me, but I'm,
Right, in one capacity versus the other.
we have lots of capacities in that office. Alright, so on page 35, see earlier comments, not all employees are at will. Okay, so since employment with Iroquois County is based on the employment at will premise, both Iroquois County and the employee have the right to separate employment at will, with or without cause. Accrued vacation time will be paid out upon separation. Some benefits may be continued after employment. The employee will receive written notification of benefits options available to them. All final paychecks will be mailed to the employee's home address on the next regular scheduled pay date. So, I think maybe deleting that first sentence would be fine, because we've already previously changed the classification of at-will employees
Right.
in the previous policy. So we could technically take that sentence out and just keep in the accrued vacation time will be paid out. Some benefits may continue, blah, 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 because we do provide a final written notification of the benefits available to them, we do that, so. Well, maybe does it.
what do I do?
The, like when they retire or whatever,
Oh, when they
give them their
retire.
letter,
Okay.
or they have their, yeah. So are we okay with keeping that
Yeah.
out, because it's already previously discussed?
Yeah, go ahead.
Okay, so moving along here, page 36, one page 37. So on number 1, she specifically, she put in county employment and taking out organization. I'm good with that. Let's see here, 37. 38. 38. 39. Oh boy. Okay,
This is a mouthful.
you wanna continue on, or I don't know what time it is, like 5 minutes have passed.
Do this one and that'll be it.
Okay, so
This is 39?
equal employment opportunity, so the comment is, see attached sample policy, which I will have to go back and get out for you guys. Harassment and sexual misconduct, which includes EO provisions, the sample policy prohibits all forms of unlawful discrimination prohibited by state and federal law. Also, the sample policy prohibits harassment on the basis of any protected status, including but not limited to sex. The sample policy includes the provisions that are required to be in a public body's policy against sexual harassment as required by Illinois law. I recommend that the county consider incorporating the sample policy, which I will print those off for you guys.
So she's recommending we just put the sample policy in place of what we have.
That's what she's recommending, but she did make some changes on here if you wanna look at it, or if you want me to print off those samples for next time.
Well, I don't see a point in going through a lot of this if we're just gonna swap it out.
We can table it.
Why don't we,
I'll email them to you and then I'll print them off for next
yeah,
time.
why don't we say we ended at page 38 and we'll start with 39 next time.
Okay. Sounds good.
Sounds good to me.
Okay, very good. Progress is slow, but we're making progress. Okay, we will not go into executive session, but the next thing we'll be discussing and determining a date for the next policy and procedure meeting. We have a situation where our next meeting, if I remember correctly, should be like the 30th of November, something of that sort, but that falls within the domain of this board. And the question comes up, in which that's really our December meeting, do we wanna have the meeting at some time in December in order that it falls under the purvey of the new board? Now, actually, the board that's in position right now remains in position, is my understanding, until the morning of December 5th, when the new board is sworn in.
I never did that one, I don't think.
So
I don't have,
we,
I can
if we do not, I think this, first of all, that with our work on this, trying to get this policy and procedure manual done, I think it's probably a good idea that we do meet for December in order to continue making progress.
well, I don't think we should do it on this board if they're gonna be dismissed.
Say that again?
I think it should be done by the new board. The next meeting shouldn't be for.
Okay,
It ended up being on December 1st, actually.
Yeah.
well, the new board is not sworn in until December 5th.
It should be after the 5th.
So this board is technically in office until that time. If some emergency arose on December 3rd, it would be under the administration of the current board.
What day is the first one?
Thursday.
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 So we can, if we are gonna operate under the idea that we wanna meet in December and we wanna meet after the new board is sworn in, then we can set a date from December 5th
I think we should.
up until, I believe it's the 13th when the board meeting is, so Anywhere in that time span, we could meet on the fifth, right after the organizational meeting of the board, we could,
Well, that would be
Exactly.
management meeting then,
right. Management's meeting that day, we
most likely, if that's what, that's the next thing.
Well, this is the reason I got this down here, so that we can decide what we wanna do. I mean, technically, we could meet in November yet, but the question is, again, how that's gonna, pertain over to the new boards.
When would you do it in November?
Hmm?
When would you do it in November?
Well, no, it'd be December first would be the regularly
Yeah,
scheduled.
whatever the date was. Well, it could be, I mean, we could meet on Wednesday the 30th if we wanted
Yeah,
to.
but you're considered the new board, what you're discussing.
Not yet, not at that point.
What are you meeting?
The
Nothing's gonna
makeup,
carry over into the new year.
Well, anything that we do as far as this would go to the new
Well,
board.
that's, okay, that's the only thing that we can deal with then.
I mean, all your reports and everything would go to the new board at the regular board meeting.
there'll likely be one or two new faces on this committee as well, when the new board is put together. I mean, there's a whole host
The
of
whole thing's a
possibilities.
ramification here.
All of us that are on this committee right now could be reduced to being nothing.
Right.
If the new office, whatever the board decides.
How can you hold a new board member responsible when he wasn't even on the board when the committee met? Because he
Well,
didn't know what
that's-
committee he's
it's-
gonna be on.
That's why we're talking.
No,
I
it's-
know,
So,
It's the continuity of a board. Anything that the previous board does, the next board is bound to. Otherwise, every contract you ever pass would have to be redone with a new board.
it's not a contract we're working on.
It's continuity of the board.
I know, but
It-
that,
Otherwise, every time one board member drops out and another one's appointed, it would nullify stuff.
the decisions that we've already made on our policy and procedure manual up to page 38, which we expect those that we did today will be approved next week, or the week after rather, but those will all carry forward. We're not gonna go back and review all that again for the new
but the
board.
future dates will carry the new boards.
Right. But the
Personnel
question,
as
but
the
the question
people who
is,
were
any
voted on.
decision that we make that comes before the meeting on December 13th is the first regular meeting of the new board. They're tasked with approving the reports of the committee that's submitted to them at that meeting. If this committee meets in November, you're submitting a report to them from an action taken by the committee from the old
I
board.
understand, I
So,
understand, it's kinda hard to do that, I
well,
think.
No, if they don't want the actions that were done during that committee, they can always
the only thing
deny them.
the only thing that normally would interfere with us meeting at a time, in other words, normally this committee meets the week before the other regular committees meet. The only thing that upsets that apple cart in a sense is the fact that as a normal part of this, all the committee chairmen report on what's gonna happen with their committee. So it wouldn't make sense to try and do that with your committees or other
That's what
committees
I'm
already
thinking.
meeting. That's otherwise what we're doing, it doesn't make any difference when we
In other words, you wanna meet and just work on this, and that's all you do.
That would be that's the primary purpose of it, yes. There may be other, if, for example, if, we approved the meeting and calendar schedule for next year. If at the meeting meeting a week from next, if somebody says, send it back to committee, then that will be done in December as well at this committee meeting, whenever it's held.
So when do we want to meet?
So the question is, when do we wanna meet? The organizational meeting is on the 5th. Management committee is meeting right after.
I would assume so.
And then the next day is the Health Committee and the Tax Committee. The day after that is Judicial, the day after that is Finance, and then after that is Highway. And then the following Tuesday is the regular board meeting. So we can meet any day, any day from the 5th, 6th, 7th,
Well, if
8th.
we have it on the first, which is regularly scheduled, then this isn't your last one here. I would keep it the same, just keep the regular scheduled.
Which would be the first.
Yeah. Why complicate it?
Right.
Well, if you do that, I think you should take out asking for committee reports, what's gonna happen to your next meeting.
Well, there's still gonna be things that, like in management, if we put something out for bid, it's still gonna have to be covered at the management meeting. I don't care who's in charge of it, it's gonna have to be on the agenda to do it. So,
I don't see how you can act upon anything in December if it's not part of the new year. If the meeting is part of the new year. And the committee, they made that.
you can't stop everything because of the change. You just have to continue on and, you know, Roger's here helping now, and then someone else will continue on doing his work.
Right, it's like I would tell the next chairman, this is what we did last month with Roger. So like if we had bids to open, I would tell that next chairman, this is, you know, we have bids to open this month, and I would let them know this is what was on the agenda for the previous month. This is what we need to put on the agenda for the next month, we have bids coming in. And I would kind of guide them with the next agenda going forward until they have the hang of it.
And you have the exact meeting in Oye.
Because if you don't,
If we
Yeah.
don't, then we're not gonna be able to open bids that next month,
Right.
because it's not going to be on the agenda.
and
We
if,
can't just not move
Yeah, we
forward
gotta
with
put it on the
things.
next, the new year's,
Right,
well, but then
Agenda.
you're pushing things
and
off.
you should have the new agenda, new year's.
Theoretically, let me just add this, theoretically, the way the state constitution has the county board set up is that every 10 years, everybody is on the board is up for reelection, so it's like you're starting out with a brand new slate. But there still are, as Lyle has pointed out, things and obligations that continue on, or you don't just cut everything off and start.
And then
And
there's a,
the other thing is that every 2 years, in the interim of that, in the interval of that 10-year period, every 2 years, half the board is up for reelection. That means there's continuity. In theory, on the 10-year anniversary, the whole board could come in brand new. Could be no carryovers at all. We're not dealing with that this time. We're gonna have a majority of carryovers and people familiar with the operation, so it's just a matter of whether how we wanna handle this, but
And on a more practical point, if we push stuff off until after the organizational meeting and don't plan anything till then Amanda can't possibly attend all the
Right.
meetings and do all the minutes in time for the board meeting.
I say let's do Thursday the 1st.
and also, next month, there's gonna be a zoning board meeting. So, you know, I would attend that, and then at the, this meeting on the 1st, I'd announce what the zoning board had decided and what it would consist of,
Right.
and that the committee would have to vote on it, whereas if you don't, if I just not considered to be on the policy and procedure committee, why it's not noted.
okay, I'm good with meeting on the 1st, which is why I put it down here so that we could talk about it and decide what we wanna do, so that
Then I make a motion that we have our PMP meeting on December 1st at 9 a.m.
Very good.
I'll second it, just to make it official.
All in favor, say aye.
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 Opposed, same sign.
Aye.
The motion passes. Okay, if we have any appointments this month, they'll be at the county board meeting. We have a little bit of correspondence, so can you reach that?
She can, it's just not part of her job description.
Yeah, really. You owe me $1 for that.
Good, let me see if I opened it yet.
Oh, pretty.
It's the report that comes on the Donovan landfill periodically throughout the course of the year saying that it's been inspected and it must be a good
Meeting was on the 6th of September.
Some of you may have gotten that already. Another one. CCI, the membership meeting is October 29th on a Saturday. That's 2 days from now. Anybody wants to go? Sign up. What is this all about? It's like something to do with trains.
A letter on the back. Flip it over.
Surface Transportation Board is from Washington DC. It's addressed to me. Well, just take a quick look at it and then make sure it stays intact, so cause I have to respond to it, I guess. In the meantime, while that's going around, we have a couple of claims here. Has everybody had a chance to see the claims? One is for $49.44 from EMA's telephone and gas and oil for $23.67.
I move to accept.
Is there a second?
I second.
Roger.
Go ahead, Roger.
Okay.
Yeah.
Is there any other questions or comments on the claims? Seeing none, call the roll, please.
What was it again?
The claims.
What was the claim again? What was it again? How much?
$49.44, that's his monthly telephone bill,
Oh, okay.
and $23.67 for gas and oil.
Aaron's,
Yes.
Alt,
Yes.
Barr,
Yes.
Awful,
Yes.
Sure.
Yes. Do we have any old business this morning? Do we have any new business? Do we have a motion to adjourn?
So moved.
Second.
All in favor, say aye.
Aye.
Opposed, same sign. The meeting will be adjourned. The meeting is adjourned.